Good morning. Yesterday we have seen part 1 of the Indian Constitution, that is Articles 1, 2, 3, and 4. We understood so many points during that time. Now let me continue the discussion on the same topic. I'll give you the additional points and some repeated points with respect to the same topic, so that our understanding on part 1 of the Indian Constitution, which talks about the Union and its territory, our ideas will get concretized. So, in order to go for that, I'll be opening another document to you and we'll discuss certain points with respect to this aspect. Right? Just wait a minute here. Now, so this is a union and it's a territory. This is the part number 1 of the Indian Constitution. Regarding that, I am going to talk to you some more additional points. Articles 1 to 4 in the part 1 of the Indian Constitution describes the union and its territories. The union and its territories are mentioned under part 1 of the Indian Constitution. Each point is important for the examination point of view. And the concerned articles are articles from 1 to 4. All the points we have known here. Now look at this. Article 1, we said that India, that is Bharat, shall be a union of states. The states and union territories thereof shall be as specified in the first schedule. Article 13A talks about territories of the states. Article 13B talks about the union territories specified in the first schedule. Article 13C talks about such other territories as may be acquired by India. So these are all the points we have seen. So let me not explain all these things once again. Let me go to the next line. Look at this. The words union of states is preferred over the federation of the states. So this is one important point for me. When I am using the word federation of the states, obviously you need to divide the powers completely between central government and the state government. But when it comes to India, we prefer to use the word union of states because the constitutional framers wanted to provide more powers to the central government. That is the reason why the union of the states is used in the constitution, but not the federation of states. I was telling you some time back, kindly recollect, kindly you need to start linking one point to the other from now onwards. I told you in the previous classes that India is a federation, but the word federation is not mentioned in the constitution. It was deliberately not mentioned in the constitution because if you go for the division of the powers, the states will become completely independent and the states will not be falling under the control or the directions of the central government. Otherwise, when we started framing the Constitution of India, the idea was different. The idea was different, saying that let there be a separate constitution for the central government, let there be a separate constitution for each state government. That was the idea during that time. But later, in the year 1947, when Pakistan has been created, when the nation has been partitioned, the idea has been changed. Just like the demand of Pakistan today, in future also, there may be a problem where some areas may be demanding for separation from the India. Obviously, it will become very difficult for the government to handle the situation if such demands will crop up in future. That's the reason why the immediate idea was to provide unity as far as India is concerned. For that reason, the idea has been changed and the concept of federation has been diverted to the union, where central government has been provided with the more powers, especially during the difficult circumstances. Central government will become more powerful than the state governments. So this is the idea. That's the reason why The words union of states has been preferred over federation of the states. Hopefully I'm clear. Next. Next one. Look at this. The territory of India consists of, kindly come along with me, one point or the other. Almost most of the points we have discussed very clearly in the previous class, in yesterday's class. This is nothing but an elaboration over yesterday's class. The territory of India consists of the territories of the states and the union territories, followed by any other territory that may be acquired by India. These are the points here. Hence, whenever I use the word territory of India, we need to talk about all the states that are present in India, all the union territories that are present in India, and other territories that have been acquired by India. Everything must come into the picture. Now, look at this next point. Union of India is different from the expression territory of India. Kindly understand each and every point very clearly and very carefully. Union of India is different from the expression territory of India. The union includes only the states which enjoy the status of being the members of the federal system and share distribution of the powers with the union. Very, very important. Union includes the states which are enjoying the status of being the members, and they will enjoy the concept of federation with the division of the powers. Whereas the territory of India includes the entire territory over which the union, over which the sovereignty of the India for time being extends. Hope you are getting this. If you use the word Union of India, then I am talking only about the states that are present within India. But if I use the word territory of India, we are talking in terms of the entire area over which the sovereignty of India for time being extends. That's the reason why, if you look at it today, as on today, there are 29 states and 7 union territories. I made a correction here. As on today, there are 29 states and 7 union territories. Look at this. Kindly remember the names of the union territories. With each and everything, you need to be very, very perfect as far as civil services examination is concerned. You must be knowing all the names here. One is Delhi, that is called Delhi, that is National Capital Territory, NCT. Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu, Pondicherry, and followed by Chandigarh. And see here, wherever I am taking the names of all the union territories, kindly mentally you just try to locate this on the map. Knowing the location of each area is also important for the examination point of view. Okay, now I am moving further. Look at this next. The names of the states and the union territories and the territories covered by each of them have been described in the first schedule of the Indian Constitution. What do you mean by this? Yesterday also I was telling you, when I say 29 states and 7 union territories, which part of the Constitution is talking about this? The names of all the states and union territories are nowhere mentioned in the Constitution, but they are mentioned in an alphabetical order in the schedule number 1. That is called the first schedule. Okay, the same thing we are just repeating here. Meaning is simple. If I want to know how many states and union territories are present, I need not go through the entire constitution. I can open the constitution straight away. I will be going to the schedule number 1. There I will be having the list of all the states and union territories that are present in India, and I can find them in an alphabetical order. That is the meaning of this. Okay, it is not just the states, It is also talking about the union territories. Everything is mentioned in the schedule number 1. Kindly remember? Yes. Now, look at this. The other countries' possessions can be added to India through the constitutional amendments. Kindly remember this, very, very important here. The other countries' possessions can be added to India through the constitutional amendments. What do you mean by this? Kindly look at this one. Yesterday, I was talking to you regarding Article number 2 of the Indian Constitution. Article number 2 of the Indian Constitution, I am talking about this. In that Article 2, I told you a concept that new states can be admitted into the Union of India. Whenever I am using the word new state, that state or that area is not already a part of the Indian Union. Hope you are getting it. And whenever you want to acquire that area, that is expected to be. Yesterday I was telling you, anything comes under Article number 2 is not considered as an amendment of the Constitution under Article number 368. But here I am saying that if you want to acquire any other area which is already under the possession of some other nation, that should be added to the Indian Union through an amendment of the Constitution. This is the point. Kindly remember here. Okay, let me show you the document. Let me explain it to you. Look at this. Through 10th Amendment of the Constitution in the year 1962, the Portuguese enclaves of Dadra and Nagar Haveli was constituted into a union territory. This was done after the judgment of International Court in India's favors. So that this particular judgment was given by International Court, and the judgment has been given in favor of India. That's the reason why, of course, the judgment was given in such a way you amend your constitution and include or admit those Portuguese enclaves into the Indian Union. Because of that reason only, there was an amendment in the year 1962, and the number was the 10th amendment, and accordingly, Dadra and Nagar Haveli has been constituted into into a union territory. Kindly remember this. When we are reading about Article number 2, we have understood very, very clearly that in order to admit any new state, I need not amend the Constitution. I can follow the simple procedure as it is mentioned in Schedule number 2 of the Indian Constitution. I'm sorry, in Article number 2 of the Indian Constitution. But here, we have amended the Constitution only to fulfill an obligation which has been created by an international court. The court has given the directions to amend the Constitution and admit that area into the Indian Union. That is the reason why we went for amendment of the Indian Constitution. Now, some people will ask me, India is a sovereign nation. Why should India listen to the directions that are given by any international agency? Kindly remember one thing. Whenever we are talking about an organization or which is an association, if India becomes a member in that association or any country becomes a member in that association, each association will have its own set of rules and regulations. And each country which is a member must follow those regulations. Otherwise, the country's membership may be suspended and the action may be taken. Since India is a member in various international organizations, India is expected to abide by the directions that are given by or the decisions that are taken by that particular organization. That is the reason why India has to accept. At the same time, we are not sacrificing our sovereignty. That is the reason why either India or any other country, it will raise its voice on the international platforms. If we have any concern with respect to any subject, yes, we have every right to raise the voice and we have every right to convince the international community. But once the decision is taken on the floor of that international organization, that is expected to be binding on all the member countries which are the part of that particular institution. This is the basic idea with respect to any any international organization. Since India is a member, India had to accept the directions that are given by International Court of Justice. Kindly remember this. Okay. At the same time, we are not sacrificing our sovereignty. Am I clear? Now, before going further, let me tell you one point. Yesterday, I had a seminar on public administration, and that seminar is available on both the sites, onlineias.com and also on the current affairs site. And the people who are interested to join public administration, the classes are going to be started from 1st January onwards. The timings will be morning 7 to 9. Since it is an online class, if you are busy at that particular time because of any reason, there is no issue because the video recording will be available. Okay. The registration process is mentioned in the registration column of onlineias.com. And if you want to join for public administration, kindly fulfill all the formalities as early as possible and join the optional, that is public administration. Okay. So don't and if you still have any doubts with respect to anything, you can just mail me or you can just call me over my mobile number. I'll give you the clarifications, but join at the earliest so that I can create a separate circle for public administration students, and the videos will be available exclusively for those people who get registered for public administration. General studies, it is open for all, I told you. But when it comes to public administration, that is available only for the registered students. Hence, please register yourself by fulfilling all the formalities. Accordingly, become a member, and we'll be starting the sessions on January 1st. And of course, there is also a column which talks about the fee structure. The fee is going to be revised after a period of time. That's the reason, become a member at the earliest. Okay. Now, I'm going to the next point. Now, hope you got it. Why we went for the constitutional amendment. Kindly remember this particular point. Look at this. In the year 2000, there was a question: which one of the following statements is incorrect, not correct? 1, 2, 3, 4. Kindly look at this. Goa attained full statehood in the year 1987. Yes, that is the right answer. Diu is an island in the Gulf of Humbat. You must be knowing this. Yes, it should be correct. Daman and Diu were separated from Goa by the 56th Amendment of the Constitution of India. Okay. And when it comes to D, Dadra and Nagar Haveli were under French colonial rule till 1954 is wrong, because Dadra and Nagar Haveli were under Portuguese colonial rule, not French colonial rule. Hence, the answer is option D. Am I clear? Now, look at the types of questions that are being asked in the examination. Hence, we need to prepare in all the directions. From various directions, we need to prepare. Look at the next point. I'm coming across. Similarly, Goa, Daman and Diu were added as a union territory through the 12th Amendment of the year 1962. Dadra and Nagar Haveli through 10th Amendment. Goa, Daman and Diu was added as a union territory through the 12th Amendment. In the similar manner, look at the next point. The Pondicherry, in fact, it was under the control of the French government. Kindly see here, When we got independence in the year 1947, that part of India which is under the control of the British government was given the independence. Apart from this, some of the areas in Indian region, they were under the occupation of the French government, and some of the areas were under the occupation of the Portuguese government. And those areas were still under the control of the respective countries. But when it comes to Pondicherry, today we are using the word Puducherry, but let me use the word Pondicherry of that time. So during that time, the Pondicherry was under the control of the French government. And in the year 1954, the Pondicherry has been ceded to India by the French government. Meaning, Pondicherry has become an acquired territory into the Union of India. But after the judgment that was given by the International Court, India also decided, though the Pondicherry is under the control of India since 1954, India decided to integrate Pondicherry area into the Indian Union through an amendment of the Constitution. That is the reason why Pondicherry, since the beginning, which is considered to be an acquired territory of the Indian Union, it has been integrated into the Indian Union through an amendment in the year 1962. Am I clear? This is the point. Kindly remember this. Now, let me open the document. So, Pondicherry, together with Karaikal, Mahi, and Yanam, were ceded to India by the French government in the year 1954. Next point. Look at this. In the year 1962, through the 14th Constitutional Amendment, Pondicherry, together with remaining three areas, Karaikal, Mahi, and Yanam, the French possessions was added as a union territory, meaning acquired territory became union territory in India. Look at the next point. As per the provisions in the Article 239A of the Indian Constitution, the Parliament, through the Pondicherry Administration Act of 1962, made a provision for the legislature. What do you mean by this? Just now I am telling you that Pondicherry is a union territory in the Union of India. That is number one. But if you look at all the states that are present in the country, every state has got its own legislature. Now the point is that if I call a particular area, as a union territory, can it have a legislature? The answer is yes. The Constitution is providing a mechanism where the Parliament can establish a legislature for a union territory. By using these provisions, Pondicherry has been created with the legislature. That's the reason why in India, out of 7 union territories we have, only 2 union territories have the state legislatures. And these 2 union territories are, number 1 is the Pondicherry and number 2 is the National Capital Territory, that is Delhi. These are the only 2 union territories which have the legislatures in their respective territories. And the remaining other 5 union territories, they do not have the legislatures. But Constitution has provided a provision for every state will have a legislature. That is the reason in 29 states today we have legislatures. Am I clear? Kindly remember this. That's the reason why number of legislatures are 29 in India. Okay, plus 2 more legislatures are also present in Delhi and Pondicherry. Hence, the number of the legislatures that is present in India is 31. Am I clear? 29 states, but 31 legislatures. The two are coming into picture because of New Delhi and also because of the Pondicherry. 29 plus 2, now the number is 31. 31 legislatures are present in India. Plus one more legislature at the higher level, that is the parliament. Kindly remember this number, very, very important. Now, let me open the document once again for you. Look at this. So, kindly remember this. As per the provisions in the Article 239A, the Indian Constitution, the Parliament through the Pondicherry Administration Act of 1962 made a provision for legislature. Next, through the 69th Amendment of 1992, Delhi is given a special status. Through this amendment, two new articles have been added to the Constitution. That is Article 239AA and Article 239AB. They were inserted providing for a legislature and a ministry for Delhi. At the same time, the Delhi has been renamed as National Capital Territory of Delhi. Very, very important. Kindly remember this. And what exactly is the status of Delhi? When we come to those articles 239AA, 239AB, then we'll try to have a detailed discussion during that time. Look at this. Apart from Delhi and Pondicherry, the rest of the union territories are the centrally administered areas and are governed by the president through an administrator appointed by the president here. Kindly remember one thing. When I am talking about the states, each state in India, meaning all the 29 states, they have the complete independence because the circumstances are normal. During the normal circumstances, central government cannot interfere with the working of the state governments. Only when the situation is not normal, then only central government will interfere. But when it comes to the union territories, the name itself is indicating that these are the centrally administered areas. That is the reason it will be these 7 union territories are under the complete control of the central governments. But for Pondicherry and Delhi, because the legislatures have been created, because the Council of Ministers have been created, they are enjoying the partial freedom, not complete freedom, but some responsibilities have been entrusted to the Chief Minister and Council of Ministers, and the responsibilities have also been entrusted to the legislature that is present at the union territory level. That's the reason why, if you look at all the 7 union territories, these 2 union territories, Pondicherry and Delhi, they are enjoying some freedom when compared to remaining other union territories. Just remember these points. When I come to that area, I'll have a detailed discussion on each and every union territory and their powers. Look at this. Look at this next point. Any territory acquired by India either by purchase or by treaty or by cession or by conquest will form a part of the territory of India. According to Article 246, Clause 4 of our Constitution, these areas will be administered by the Government of India and subject to legislation by the Parliament. What do you mean by this? So there is a possibility, so there is a provision that is available in the Constitution where India can acquire the areas. And this acquiring can be done either by purchase or by treaty or by cession or by conquest. Then that will automatically become the part of the territory of India. But the point is that who will control those areas? and these areas will be administered by the government of India, subject to the legislation by the parliament. Meaning is simple, they come under the control of the central government, and with respect to the laws, those laws are made by the parliament. Look at this. The Pondicherry, together with the Karaikal, Mahi, and Yanam, were ceded to India by the French government in the year 1954, was administered as acquired territory until 1962. We know this point. Next, after ratification of the Treaty of Cession by the French Parliament, this area was constituted as a union territory in December 1962. Very, 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 very important. Okay, in the year 1954, this area was ceded to India. At that time, it was called acquired territory. But in the year 1962, after ratification by the French Parliament, this particular area has been constituted as a union territory in the year 1962, and this happened through an amendment to the constitution. Look at this. I am coming to article number 2. Already we have seen. Just read once again on your own. Parliament may by law admit new states into the Union of India or establish new states on such terms and conditions as it thinks fit. This is what we have understood yesterday. Okay. Again, let me not explain you all the points because I explained you all the points in yesterday's class. Look at this. Article number 2 is providing two powers to the parliament. It is providing two powers to the parliament and the power to admit the new states into the Indian Union. I told you already, number 1 power is the admitting the new states into the Union of India. Whenever I use the word admitting the new states into the Indian Union, it is nothing but this is an area which is not already a part of the Indian Union. We are taking this area from outside. Number 1. Number 2, it also has the power to establish new states. Meaning two things are coming into picture. Number 1 is the admission. Number 2 is the establishing the new states. Both are mentioned under article number 2. Look at this. And article 2 specifically relates to the administration or establishment of new states that are not part of the Indian Union. Yesterday I was telling you one point. When if we are using article number 2, if we admit any new state into the Indian Union, we are altering the external boundaries of the Union of India. Meaning the concept of modifying the external boundaries of the Indian Union are covered under article number 2. Okay, I told you yesterday itself, article number 3 is altering the boundaries internally, internal boundaries. Article number 2, external boundaries. Okay, now let me tell you this point, how Sikkim became an Indian state. Okay, let me go through this very fastly. During the British days, Sikkim was an Indian state. The Sikkim was under the hereditary monarch called Chogyal. In the year 1890, the external boundaries of Sikkim were demarcated with China by an agreement. And the Chogyal was a member of the Chamber of Princes. After India became independent, a treaty was entered into between Sikkim and the government of India. This is an agreement after India became independent. The government of India took the responsibility with regard to defense, external affairs, and communications of Sikkim. Meaning Sikkim was completely a separate territory, but some responsibilities have been taken over by Indian government, and those responsibilities are with relation to the defense, external affairs, and the communications of Sikkim. That's it. Now, now look at this. Sikkim became the protectorate of the Union of India. meaning it became a part of the Indian Union, but not completely a part here. Because some areas are under the control of the Indian government, it became the protectorate of the Union of India. In the year 1974, kindly follow this, the Sikkim Assembly passed the Government of Sikkim Act of 1974, and this act empowered the government of Sikkim to seek participation and representation of the people of Sikkim in the Indian political institutions for the speedy development of Sikkim. As long as the Sikkim is a separate territory, obviously, because the area is small, the government does not have the experience, internal problems will be there. So during that time, they wanted to have the participation of the people of Sikkim in Indian political institutions, so that they have expected that that will lead to the faster development of Sikkim. Now, the Chogyal was turned into a normal constitutional head, and the real powers have been transferred to Sikkim Assembly. Till that time, he was the real executive. He became nominal, and the real powers have been given to Sikkim Assembly, and that assembly passed a resolution expressing the desire to be associated with the political and economic institutions of India. Slowly, the new ideas have come up, and this moment, yes. Now, the resolution also meant for the representation of the people of Sikkim in Indian Parliament. Accordingly, we went for the 35th Amendment in the year 1974, and this particular amendment was given effect to the resolution. Look at this. The main provisions of the 35th Amendment Act were: Sikkim will be an associate state of India. I have written one more word here, that is called associate. Already we have seen India comprises of states, union territories, and acquired territories. But now we are coming across with the words associate state, meaning through 35th Amendment, Sikkim was given a status of an associate state, and this amendment was done. Later, so there was an uproar in India. Where is this associate state status is provided in the constitution? How can you provide this particular status to Sikkim? In order to rectify these mistakes, again we went for another amendment, that is the 36th Amendment, through which Sikkim was inducted into the Union of India as a full-fledged state. Meaning is simple, because of any reason, through any amendment, if there is a mistake, that mistake can be rectified by amending the constitution again. So this is what happened. So kindly remember, associate state is not mentioned in the Constitution of India. Now, through this 35th Amendment, look at this, what happened. Sikkim was brought within the framework of the Indian Constitution by inserting Article 2A. A separate article has been added for Sikkim, and a separate schedule was also added for Sikkim, that is the 10th schedule. Then Sikkim will be entitled to send two representatives to the Indian Parliament, meaning this particular amendment has permitted that there will be a representation in the Indian Parliament from Sikkim. But these representatives will not be entitled to vote in the election of the president and the vice president. At the same time, these two members will also be subjected to the disqualification under the Indian Constitution. The people of Sikkim would have the right of admission into the institutions for higher education, and they can also be entitled to enter the All India services. So many provisions have been provided. Look at this next one. The defense, communication, external affairs, and social welfare of the Sikkim will be the responsibility of the government of India. Just like the previous areas, It also added one more concept called social welfare that will become the responsibility of India. Plus, there will be a representation from Sikkim in the Indian Parliament. So many things have been coming to the picture, and we added Article 2A. We also added Schedule number 10. Now, the government of Sikkim shall retain the residual powers on all matters that are not provided for in the 10th schedules. Okay, these are the things that is what happened through the 35th amendment. Now, there was a criticism regarding 35th amendment of the constitution. Since the original constitution did not mention about the associate state, hence, how come there will be the representatives in the parliament from Sikkim without being part of Indian Union? This was the basic criticism during that time. So, in order to rectify this mistake, on April 10th, 1975, they have passed another resolution. They have passed another resolution that the institution of Chogyal is hereby abolished, meaning the institution of Chogyal is gone, and Sikkim shall henceforth be a constituent unit of India, enjoying a democratic and fully responsible government. Meaning, Sikkim Assembly expressed its interest to become a complete part of the Indian Union, just like any other state. It also wants to enjoy a democratic and fully responsible government. And the referendum on the resolution got overwhelming majority. Hence, the Council of Ministers, headed by the Sikkim, headed the ministers, headed by the Chief Minister, requested the government of India to implement the decision of the referendum. Then, the Parliament has passed the 36th Amendment Act, and the same was ratified by the required number of states under Article 368, Clause 2. Next, what is this 368 Clause 2? We'll try to see when we come to that area. But here now, Sikkim has been admitted into the Union of India as a state by amending first schedules. Number one, we have added the name of Sikkim into the schedule number 1. We also allocated the seats to Sikkim in the Rajya Sabha. Hence, fourth schedule was also amended. Composition of the Council of States has been changed by amending Article number 80. You need to increase the strength, right? And the composition of the House of People, as mentioned under Article number 81, it also has been amended. At the same time, the Article 2A that was added through the 35th Amendment has been deleted through the 36th Amendment. 10th schedule, which was added through 35th Amendment, has been deleted. Hope you are getting this. This is how the changes will be made. Look at this now. And 36th Amendment Act came into effect from April 26th, 1975. Clear? At the same time, Article 371F was inserted to make some special provisions relating to the admission of Sikkim. Let me come back to you for a moment. Hope you are getting it. Yesterday, I was just touching the areas under Article number 2, how the states, how the new areas will be admitted into the Union of India. But today we have seen with the live examples how we have acquired these areas, how they have become the part of the Union of India. We have seen what happened with the Pondicherry. We have seen Goa, Daman and Diu. We have seen Dadra and Nagar Haveli. And now we have seen about the Sikkim. So these are all originally, they were not a part of the Union of India. Later they became part of Union of India. Hope you are getting it. That is the reason I was telling you the names of all the states and union territories are mentioned under first schedules. So in the original constitution, in the first schedule, all the names just I spoke to you, they were not present in the constitution. in the first schedule. Later, they were added. This is how the changes will take place even in the constitution. And kindly remember, very frequently the questions are coming from even from article number 2. Kindly revise this particular topic once again. The notes is available in the site and read all the points from the site. Now I am going to talk to you regarding article number 3. And when it comes to article number 3, already we have discussed in a detailed manner yesterday how exactly the parliament will create the new state, or the parliament will formulate a new state. Under article number 3, we are going to modify the internal boundaries of India. Article 2, external boundaries. Article 3 is the internal boundaries. Okay. So let me show you some live examples to what exactly happened here. Now, let me open the document straight away. Let's have a discussion on this. Now look at this. When I'm talking about article number 3, it says that all the points you know. The parliament may by law is empowered to form a new state by separation of territory from any state, by uniting two or more states or parts of the states, by uniting any territory to a part of any state. At the same time, Parliament can increase the area, it can diminish the area, it can alter the boundaries of any state, it can also alter the name of any state. Okay. Now look at this. Look at this. The Constitution empowered the Parliament to recognize the boundaries of the states by a simple majority. Sorry, Parliament to reorganize the boundaries of the states by a simple majority. That is the reason why I told you yesterday also, I made it very clear. Look at this point once again. Wherever you are coming across with the word, the Parliament may by law. This is the area where we are talking about a bill should be introduced in the Parliament, and that bill is an ordinary bill. Am I clear? Because it is an ordinary bill, how it is going to be passed, we know whole story. So under article number 3, a new state can be created by the parliament by passing an ordinary bill with a simple majority. Look at this. The constitution empowered the parliament to reorganize the boundaries of the states by a simple majority. And it lays two conditions. Number 1, the bill can be introduced in the parliament only with the prior recommendation of the president. Kindly recollect all the points. Yesterday I told you this one. Originally, prior recommendation of the president was not a requirement. But in the year 1955, by amending the constitution, we have added this particular area. So hence, since that time, recommendation or permission from the government before you introduce a bill which is meant for creating a new state is a must. Originally, that was not a requirement. Now it is a requirement. And the president will be forwarding the bill to the state legislatures where the state which is going to be affected with this particular bill. And I told you already, this is basically meant only for expressing the view by the state legislature, and the views are not binding on the president. Whether it is binding or not, that is not explained clearly in the constitution. But since the constitution has not said it is binding, obviously it is not binding on the president of India. The state legislature should express its view in the time specified by the president, and the president is not bound by the view of the state legislatures, because India is a parliamentary form of government where the president is depending on the advice that is given by the prime minister. Look at this. At the same time, it is also not necessary to make a fresh reference to the state legislature every time an amendment to the bill is moved and accepted in the parliament. Meaning, the bill the concerned bill comes to the state legislature through the President of India only one time. Every time it need not come to the state legislature whenever any change takes place in the parliament. But in the case of union territory, no reference need to be made to the concerned legislature to ascertain its views, and the parliament can itself take any action as it deems fit. Very, very important here. The president will be sending this bill to the state legislature only when we are talking about the states. But in the case of the union territory, there is nothing like sending for the opinion of the legislature, and the decision can be taken directly by the parliament. Next one. If you look at article number 4, I told you already yesterday again, whatever we have under article number 2 and 3 are not considered to be an amendment of the constitution. Yesterday I made it very, very, very clear. Kindly go through that particular topic once again. Let me read it for you. Article 4, clause 1 says that any law referred to articles 2 or 3 shall contain such provisions for the amendment of the first schedule and fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain such supplemental, incidental, and consequential provisions. 4 clause 2 is saying that no such law as aforesaid shall be deemed to be an amendment of this constitution for the purpose of article 368. Right? So this is what we have understood yesterday. Kindly look at this. It means that these can be passed, meaning whatever we are going to do under article number 2 and 3, that can be done only with the simple majority. We need not go for the special majority. Okay. Next one. But already I told you we have added Dadra and Nagar Haveli, Daman and Diu, Goa, followed by this Pondicherry. All the areas have been added to the Union of India through an amendment to the Constitution, because we have given respect to the directions that are given by international court. But otherwise, nothing to do with the Constitution of India. This can be done by a simple majority of the parliament, like any other piece of ordinary legislation. Next one. Reorganization of the states in independent India. This is completely related to part 1 of the Indian Constitution. We'll see. After the independence, there has been a demand for the reorganization of the states. But kindly remember one point. Let me say one point here regarding this one. I told you already, the names of all the states and UTs are mentioned in schedule number 1. But the original schedule number 1 of the Indian Constitution divided Indian states into A, B, C, D categories. Right? I'll show you the list now. A, B, C, D categories are there. But in the year 1956, through 7th Amendment, this particular distinction has been abolished. So since 1956, November 1st, there is the categories of A, B, C, D has been abolished, and all the states and union territories have been put together. Okay, and this is there with respect to 1956 onwards. But otherwise, in the part A, B, C, D, we have 28 states and 1 union territory. Altogether, 29 were there. Over a period of time, because of the various developments that are taking place in India, some changes have been taken place, and finally we created 14 states and 6 union territories by November 1st, 1956. From that day, again so many changes have been taken place, and as of today, we have 29 states and 7 union territories in India. Hopefully I'm clear. I'll show you all the points. Kindly pay a greater attention. I am coming across with some commissions. These commissions are also important for the examination point of view. Hence, pay great attention here. Look at this. I am opening the document. Look at this. After the independence, there has been a demand for the reorganization of the states. In June 1948, kindly see here, we got the independence. Immediately after that, very next year, the government has appointed a linguistic provinces committee, and the chairman was S.K. Dhar. And the report was submitted in 1948, in the same year, December. And this commission recommended the reorganization of the states should be on the basis of administrative convenience rather than the linguistic factor. You reorganize, there's no issues, but kindly reorganize on the administrative convenience rather than the linguistic factor. Linguistic means taking language into consideration. Don't bother about the language, but bother more about the administrative convenience. This is the recommendation that was made by S.K. Dhar committee. It was called Linguistic Provinces Committee. And this report created a resentment. So some areas are not happy with this report. Hence, in December 1948, another linguistic province committee was appointed to examine the whole question afresh. Because majority of the areas are not happy with S.K. Dhar commission report, another commission was appointed in the same year with the same name, and this committee was also called JVP committee. Kindly remember this name, very, very important one. First one was S.K. Dhar committee. Second one is the JVP committee. It consisted of 3 members. JVP stands for, J stands for Jawaharlal Nehru, V stands for Vallabhbhai Patel, that is Sardar Vallabhbhai Patel, P stands for Pattabi Sitharamaiah. This is called JVP. Kindly remember this. There was no chairman for this committee, and it submitted the report very next year in the month of April, and the committee rejected language as the basis of reorganization. No language. Now, look at this. In the year 1953, the government created Andhra state by separating Telugu speaking area from Madras state. I told you this point already. Even when the British was present in India, there was a demand that the Telugu speaking area from Madras state should be separated. Madras state, today I am using the word Tamil Nadu state, but at that time it was called Madras state. And the people who are speaking Telugu, they have demanded that their area should be separated. And by conceding this demand, the government has created Andhra state by separating the Madras state, meaning we have bifurcated Madras state and we created Andhra state. That Andhra state is nothing but today's Andhra Pradesh, the newly created Andhra Pradesh here. Okay, the new name, which consists of 13 districts. The coastal Andhra Pradesh plus 4 districts that are present in the Rayalaseema region of this Andhra Pradesh. It was originally the part of the Andhra state. So this is how, so in the year 1953, the first state was created, and that was the Andhra state. Later, the formation of Andhra state has intensified the demand from other regions for the creation of the states on the linguistic basis. Because that area was separated, and the idea was that this is the Telugu speaking area. So obviously, the demand has been started from other areas also. And that is the reason why in the same year, in 1953, in December, the government constituted a 3-member committee that is called States Reorganization Commission. Kindly remember, in India, so far, we have established only one SRC, that is the States Reorganization Commission. Why I am telling this to you? Because this SRC is coming into the discussion so many times nowadays. Whenever there is a demand from any state with respect to the division, during that time, the government is touching the concept of SRC. But kindly remember, till today, there is only one SRC that was established. And the chairman was Fazl Ali, kindly remember this name, possible question. And other two members were K.M. Panikkar and H.N. Kunjru. These are the two members. It submitted the report in 1955 and it accepted language as the basis for reorganization. Remaining two committees, they did not accept the language as the basis for reorganization, but SRC recommended that a language as the basis for reorganization. Look at this. It rejected the theory one language, one state. It recommended, can you look at this? Abolition of a classification of the states and the creation of the 16 states and 3 centrally administered territories, meaning 3 union territories. The government accepted the recommendations with modifications. Accordingly, the States Reorganization Act of 1956, at the same time, Seventh Amendment has been taken place, and the distinction between Part A and Part B states were done away with. The distinction between Part A and Part B has been removed, and Part C states were abolished. Abolished in the sense, look at the next point. Some of the Part C states were merged with the adjacent states, and some of the Part C states were disintegrated as the union territories. Okay, so there was a merger between Part A and Part B. Part C has been abolished, meaning they were merged with some other states and some have been designated as the union territories. Kindly follow all the points very clearly. On November 1st, 1956, we have created 14 states and 6 union territories. Very, very, very important. Hope you are following all the points. Look at this. States as of November 1st, 1956. Of course, this is not important for you, but just to have a look at this. It's called Andhra Pradesh, Assam, Bihar, Bombay, Jammu and Kashmir. Look at this, how it is present. Most of the areas that is present in the northeastern part today, that entire area put together was called Assam. And if you look at this, Bombay, today's Maharashtra plus today's Gujarat put together was called Bombay state, right? Next, Jammu and Kashmir, Kerala, Madhya Pradesh, Madras, Mysore, Orissa, Punjab, Rajasthan, Uttar Pradesh, West Bengal, and union territories. Look at this: Andaman and Nicobar, Delhi, Himachal Pradesh, Lakshadweep, Minicoy, and Amnidiv Islands, Manipur, followed by Tripura. So these are considered to be the so-called the union territories. Kindly look at this. Himachal Pradesh is a state today. Manipur is a state today. Tripura is a state today. Meaning the status of union territories has been changed to state. Okay, look at this. Creation of the new states after 1956. Look at this, 1956. In the year 1960, now you know how a new state will be created. Okay, very fastly, let me tell you these points. In the year 1960, Bombay state was divided into Maharashtra and Gujarat. Okay, next. Dadra and Nagar Haveli was converted into a union territory in 1961 through the 10th Amendment. Again, Goa, Daman and Diu were acquired and constituted as union territory through 12th Amendment. Goa was conferred a statehood in the year 1987 by the Goa, Daman and Diu Reorganization Act. Look at this. Pondicherry was made a union territory. 1963, Nagaland was created by taking away Naga Hills and Susang area out of Assam. This was done through the State of Nagaland Act of 1962 with effect from December 1st. Later in the year 1966, Punjab was bifurcated through Punjab Reorganization Act. This created 17th state called Haryana and a new union territory was created by name Chandigarh. Later in the year 1971, through the State of Himachal Pradesh Act of 1970, the Union Territory of State of Himachal Pradesh was elevated to the status of a state. Later again, in 1971, through Northeastern Areas Reorganization Act 1971, the two union territories and the substate of Meghalaya got statehood, and the union territories Mizoram and Arunachal Pradesh. Kindly remember this one, very, very important. Whatever I am talking to you now, you need not remember what happened to each stage, how they have been created, but try to remember at least one or two, and try to remember the latest one, like Telangana state, which was created, and the Mizoram and Arunachal Pradesh, formerly called NEFA, Northeast Frontier Agency. Later, through 36th Amendment, we got Sikkim. In 1987, Mizoram, Arunachal Pradesh, Goa were created. In the year 2000, three new states, you know this, Chhattisgarh, Uttaranchal, and Jharkhand. They were created. Later, Uttaranchal has been renamed as Uttarakhand. Look at this. Chhattisgarh was created through Madhya Pradesh Reorganization Act. Uttaranchal was created through UP Reorganization Act, and Jharkhand was created through Bihar Reorganization Act. Look at this. Gujarat was the 15th, Nagaland was the 16th, Haryana was 17th, Himachal Pradesh, Manipur, Tripura, Meghalaya, Sikkim, Mizoram, Arunachal Pradesh, Goa, Chhattisgarh, Uttaranchal, and Jharkhand. Okay. And now, if you want to add, you can just add one more name here. So, this is the new state called Telangana. It's called Telangana. This is the latest state for us so far. Okay. Now, look at this. The names of the states can be changed through the provisions of Article number 3. Look at this. I told you some points. The name was United Provinces. It has been renamed as Uttar Pradesh. Hence, today we are using the words Uttar Pradesh. In 1969, Madras was renamed as Tamil Nadu. In 73, Mysore was renamed as Karnataka. Later, in 1973, look at this, Lakkadiv, Minicoy, and Amnidiv Islands renamed as Lakshadweep. And again, Delhi was redesignated as NCT, National Capital Territory of Delhi. Okay, so remaining all the miscellaneous points are there. You can just have a look at this. Look at this. In Amar Singh versus State of Rajasthan of 1955 and Mastan Sahib versus Chief Commissioner, the Supreme Court held that the territory of India at any point of time is the territory specified in the first schedule under Article 1 of the Indian Constitution. Important. Whenever we talk about the territory, all the areas that are specified under Schedule number 1 will become the part of territory of India. Look at this. I told you this point again yesterday. There was a discussion in the Constituent Assembly whether to use the name Bharat or India. And finally, we have accepted as a compromise, let both the names should be used. That's the reason Article 1 says that India, that is Bharat, shall be a union of states. Now, no state in India could secede from the union. Very, very important. Internally, there can be a changes. Boundaries can be modified. But no state can demand that it will get separated from the union. Look at this. The parliament's power to diminish the area of any state does not cover cession of Indian territory to a foreign state. But look at this. The problem is that we can acquire any area from outside, but at the same time, can we give away our areas to any other country? That is not mentioned in the constitution. That is the reason why the Berubari case plays very, very crucial role here. In the Berubari, which is a part of West Bengal, in this case of 1960, on the presidential reference to the Supreme Court, The court expressed the opinion that no cession of territory could be made without a constitutional amendment. It is not mentioned in the constitution, but even today also it is valid because this is the opinion, this is the direction, this is the judgment that is given by the Supreme Court. Accordingly, to give effect to an agreement with Pakistan for transfer of part of the Berubari territory, the ninth constitutional amendment took place in the year 1960. Through this particular amendment, the area which is part of West Bengal, some part in the Berubari territory has been given away to Pakistan through an amendment of the constitution, and this is because of the directions that are given by the Supreme Court, and nothing is mentioned in the constitution. So since then, even today also it is valid. Kindly remember another point. Today there is a proposal that is going on. Of course, it is coming to an end. In fact, since 1971, after Bangladesh has been separated from the Pakistan, the discussions between India and Bangladesh are going on, where the exchange of territories are taking place. Some part of India is being given to Bangladesh. At the same time, the Bangladesh area, some areas are coming to this Indian territory. How are you going to do it? Because if you want to acquire, you can acquire through an amendment. At the same time, by taking the spirit from the Berubari case, the judgment that is given by the Supreme Court, India is giving away some of its territories to Bangladesh. Some of its territories are going to Bangladesh, and this is going to happen through constitutional amendments. Okay, kindly remember this one. Whenever you are talking about giving away your areas, first you need to mention about Berubari case, and you need to mention even today's the territories are being given away to Bangladesh. Again, that is happening through the constitutional amendment. Am I clear? Now, let me open the document now. This is how, kindly remember, this is how you need to link up the areas that are present in the constitution with the current affairs. Then only you will get the life to your answers. It should not be the static answer every time. If it is static answer, just like any other person, you are also getting the marks. But in order to score more than others, the current affairs touch must be given to the answers, then automatically you will be getting very good marks. Look at this. In the year 1969, the apex court ruled that the settlement of a boundary dispute between India and another country does not require a constitutional amendment. If you are giving and taking, then you go for the amendment of the constitution. But the same court said that settling the dispute does not require any constitutional amendment. It can be done through executive action. Since it does not involve cession of Indian territory to a foreign country, you are just settling the issues. That's the reason why here, look at this. India is an indestructible union of destructible states. As a union, we are indestructible, but states are destructible. What is the meaning of this? We can break the existing states or we can merge the existing states. Okay, kindly remember, India is an indestructible union of the destructible states. Next, the country is described as a union, although the constitution is federal in structure. You know the meaning of this, right? And USA is described as indestructible union of indestructible states. This is with respect to USA. At the time of independence, India comprised of two categories of political units. Number one is the British provinces. Number two is the princely states. And Indian Independence Act of 1947 gave three options to the princely states, either to join India or Pakistan or remain independent. Out of that, 552 princely states, 549 got integrated with the Union of India. Later, Hyderabad was integrated through police action. Junagadh was integrated through referendum. Kashmir was integrated through instrument of accession. Okay, and the Indian Constitution of 1950, it contains 29 states, and these states were divided into four parts. Just have a look at this. Part A, 9 states are there. Look at this. Assam, Bihar, Bombay, Madhya Pradesh, Madras, Orissa, Punjab, and followed by United Provinces and West Bengal. Again, in part B, we have 9 more. Hyderabad, Jammu and Kashmir, Madhya Bharat, Mysore, Patiala and East Punjab, Rajasthan, Saurashtra, Travancore, Cochin, and Vindhya Pradesh. There is part C. It consists of 10 states: Ajmer, Bhopal, Bilaspur, Kuch Behar, Kurg, Delhi, Himachal Pradesh, Kutch, Manipur, and Tripura. I'm just reading it only for you. You need not remember all the points. Okay? Look at this. In the part D, we have the Andaman and Nicobar Islands. Now, look at this. These are some things I have with me. Look at the latest one. In January 2012, one of the important political parties in Tamil Nadu, that is Dravida Munnetra Kazhagam, which is presently it is headed by Karunanidhi. It is called a DMK party. It demanded that the taluks of Devikulam and Perimedu, which are now in Kerala and forming the parts of the catchment area of the Periyar River, be merged with Tamil Nadu. See here, this demand was started in 1956 and 57. Even today also the demands are going on. Meaning, even after the independence, even after the commencement of the constitution, even after going through so many years, these demands are still there, and they will become a cause of dispute between the states. Whenever you are coming across with such type of disputes between any two states or three states, kindly make a note of this. And the latest one you are expected to write in the examination. Right? Look at this. Of course, I'm just removing this. This is an old point. The decision of the creation is done, and of course, it was also done. Telangana has been created. Old point. I'm just leaving it. Next one. Vidarbha is in Maharashtra. There is a demand for a separation. Gorkhaland, that is present in West Bengal. Again, there is a demand for separation. Bodoland and Karbi Anglong is in Assam. Again, there is a demand here. At the same time, Paschimachal, Haridra Pradesh, Bundelkhand, Awadh Pradesh, and Purvanchal in the state of Uttar Pradesh. So there is a demand for the separation. So maybe in future it may happen. We'll try to see. We'll see in future. But kindly see here. There was a question in the year 2001. Look at the question. Simple question. UPSC. If a new state of the Indian Union is to be created, which one of the following schedules of the Constitution must be amended? You know the answer. That is the first schedule, right? Look at this. Again, similar type of question in the year 2003. Which one of the following schedules of the Indian Constitution lists the names of the states and specifies their territories? Answer is the first schedule. Okay, look at this. This is a question asked in 2006. Now the question is that which of the following pairs is not correctly matched? Okay, look at this. A, B, C, D. And if you look at answer D, so answer should be the D here. Not correctly matched. Gujarat became a state in the year 1960 and not in the year 1966. Okay, in 1966 it was Punjab was bifurcated and Haryana was created. Okay, now, so this is the story with respect to this is part 1. Kindly see here. Yesterday and today you heard about the part 1 of the Indian Constitution. If you want to revise this topic today, you please revise the topic for 1 time, 2 times, or 3 times. But once this particular topic is over, your preparation with respect to part 1 of the Indian Constitution is over. Okay, tomorrow morning, before I take up other part, I'll show you some questions, and I will and you try to write answers for that. Okay, I'll give you some descriptive questions. The more you write, the more you become comfortable. If you want to achieve IAS in one attempt, you need to follow my guidelines. That's it. Okay, you need to work hard. We need to work hard rather, in order to see your success. For that reason, again, I am going to give you some questions tomorrow, and by tomorrow evening I want answers from you. Am I clear? Fine. So thank you so much for being with me this morning. Have a very good day. See you in the next class.